that. And let me just go to slideshow mode.
And where are you joining
We're
us?
in business. Oh, so and I apologize for my casual attire. It's not how I normally appear at a meeting like this, but we're based outside of DC at the Treatment Advocacy Center. I'm actually on vacation now in the mountains of New Mexico. This opportunity arose. I was here and I'm here still. So no disrespect intended, but great to be with you. And I will take about 20 minutes to just give a basic overview of what AOT is, what it seeks to achieve, and hopefully with the time I have left, just kind of contrast that a little bit with what's been attempted so far with the OCC project as I've observed it. My organization, I should say, we work around the country to remove legal barriers to the treatment of severe mental illness. Having AOT become a routine practice of every public mental health system has been the top of our agenda for the 20 years of our existence. And Maryland has been a white whale for us, as many of you know, having been involved in these debates over the years. We're down to just 3 states that don't have an AOT law on the books, Maryland being one of them. And needless to say, we would love to change that. So let me just start by making clear that we are not proposing that having AOT would be some kind of a or everything that challenges the public mental health system in Maryland. Wherever we do our work, we encounter these same many challenges that face public mental health. AOT is not a cure-all. I've listed just a few things that are common challenges nationally, and I'm sure with this group we could fill many, many more slides with others. Having an AOT law on the books will not make all these issues go away. It is designed to address a particular problem, which I think probably doesn't get enough attention, that universally vexes public mental health systems, and that is the problem of treatment non-engagement. The fact that for many individuals, even if you are able to solve these resource deficits that drive so many of these other problems, you have some folks who, by no fault of their own, as a corollary of their mental illness, have difficulty engaging with outpatient treatment and disengage from services that are made available to them. And of course, that particular problem puts lots of pressure on all these other issues, because it does create this small core of folks who are trapped in this revolving door, consuming a disproportionate share of resources because they're coming back into the system again and again, making that much less available for other people who are not in that particular situation. So what we're trying to do with AOT, this is a Phillips head screwdriver, where it's designed for a specific problem that you are facing, which is this problem of treatment non-engagement. And again, this is for folks who are caught in the revolving door, both of the criminal justice system and the mental health system, which is having lots of negative consequences for both systems, leading to just tremendous costs placed on the system and having to respond to crisis repeatedly. It's taking a terrible toll on these individuals themselves, just because we know that successive psychotic breaks that people go through, right, push recovery further out of reach. It puts mileage on the brain, so to speak. We all like to speak very carefully about the fact that violence and crime is associated with untreated severe mental illness, not with mental illness in general, but certainly with this particular population, it's not really something we can ignore. And so it's worth wondering what this problem of treatment non-engagement is about. Why are there some people with mental illness that, unlike what we see with other types of illnesses, have such great difficulty engaging with the treatment that's made available to them? And again, I don't want to be overly simplistic in addressing these questions. There are lots of answers to that. In any particular person's case, you're likely to find many reasons why they're having trouble engaging with treatment. Again, I've listed a bunch of the common ones. And again, I'm sure we could fill many more slides with other reasons. But the one I've highlighted in yellow is one I think we need to pay particular attention to for reasons I'll explain. And it's one I don't think gets enough attention. And it's this problem of anosognosia, lack of insight. The fact that some people with severe mental illness have great difficulty recognizing their need for treatment. This is a symptom of brain dysfunction. This is no more a person's fault than any other dysfunction of an organ of the brain. And we are simply talking about the fact that some folks are simply unaware that they have an illness. And this may be something that is fixed for some individuals. For others, it may be something that waxes and wanes, comes and goes. But we need to understand when a person is experiencing anosognosia, they are unaware of their illness. This is sometimes mistaken for denial, conflated with denial. People will say, my son's in denial, doesn't want to take his meds. It's important for us to understand as policymakers that denial is not what's happening here. You know, denial is a universal human defense mechanism. It's something we all practice from time to time. When you are in denial, you actually do know the truth deep down, but maybe need somebody's help to coax that to the surface. For someone who is experiencing this brain dysfunction, they are certain to their core that they do not have a need for treatment. And from that perspective, it makes non-adherence with treatment perfectly logical, right? When you're only seeing the downsides of being engaged with treatment, not seeing what it is doing for you, only seeing the hassle involved, and let's face it, the unpleasant side effects that are unfortunately still associated with some of these meds, it makes perfect sense that a person would be disengaged. Here's just a quick slide to show you that this is very much about brain dysfunction. Here you see the brains of two folks with schizophrenia being asked to perform a self-reflective activity. One individual has been recognized as having anosognosia and the other not. And you see synapses firing in the brain of the person who has insight that simply are not for the other individual. So why do I make the case that this is a particular problem we want to pay attention to if we want to meaningfully address the problem of treatment non-engagement? There's a really fascinating study that was published in the journal Psychiatric Services that looked at 300 individuals who had chronic difficulty engaging with outpatient treatment. They started with baseline interviews of these folks and found that actually most of them did not experience an anosognosia. Most of them did recognize at the moment they were interviewed that they had a mental illness. It was only about a third of the sample that were found to lack insight into their illness. And so that speaks to the fact that there are lots of other reasons why people may disengage with treatment. But when these 300 individuals were tracked over time in this study, there were these remarkable correlations found between that third of the sample that lacked insight into their illness, insisted they were not mentally ill, and the types of ways and the severity of ways people suffered as a result of that non-adherence. So people who lacked insight were much more likely to completely stop taking their meds, much more likely to have severe symptoms, much more likely to be hospitalized on metric after metric. These were the folks who we found to be trapped in this revolving door. And this kind of brings me to my bottom line on anosognosia. And here I like to invoke that corny movie, no pun intended, Field of Dreams, where we remember that iconic line, if you build it, they will come. And that very argument is made about our mental health system. I know I've certainly heard it a lot in the debates we've had on this issue in Maryland, where many folks who I have great respect for say that the problem is simply that we have not built this great system of community-based care. And if we do that, people will come flocking to it. And I don't want to put myself in direct opposition to that point of view, because I actually do think for many individuals, it's true. Not everybody is appropriate for AOT. But I also think we have to recognize that building that system is not going to be enough for folks who lack insight into their illness, because it's just logic dictating that someone is not going to want to avail themselves of a system, no matter how well-resourced it is, if they don't believe it addresses a need they have. And so that is this need to do something more. By all means, let's all work together to build that great system of community-based care, but let's recognize the need for a mechanism to ensure adherence to treatment for people who lack insight. And that's where this concept of AOT, assisted outpatient treatment, comes into play. And this is essentially about a collaboration between the court system and the clinical treatment system. It's a collaboration between the two to overcome an individual's natural inclination to disengage from treatment. This is a form of civil commitment. This is about civil commitment to outpatient care. We're all familiar and recognize the need, I think, for civil commitment to inpatient care where a person is in acute crisis, doesn't recognize they need to be in a hospital. And so we as a system and as a compassionate society make that decision for the person at that moment in time. Here we are looking not so much at the person's current state of crisis and clinical condition, but we're looking at their history of winding up in crisis because of their difficulty engaging with treatment. And we're going to, with these laws, draw criteria that seek to identify folks who have this particular challenge in relation to their mental illness. And the idea here is that we are trying to leverage the power of the courts, the significance of a court order to influence a person's behavior and help them to make decisions about their outpatient treatment they otherwise would not. Let's talk just a little bit quickly about this court order, because I think it's important to understand that this is very different from what those of us who are attorneys normally associate with a court order. If we were to have a law like this on the books in Maryland, we would have provisions, as we do in many other states, that make it just fundamentally different from typical court orders. And ordinarily, the reason a person follows a court order is they don't want to be held in contempt of court. They don't want to be punished for disobeying what the court has directed. Here, we would take that off the table. We would say you cannot be found in contempt of court for violating this order. We are, after all, trying to help people stay out of jail, not create a whole new reason for someone to wind up in a jail cell. We are not going to automatically return someone to a hospital for violating the terms of their order if they don't meet the standards for inpatient commitment in the state. We are not going to use this as grounds to forcibly administer meds, that is, restrain a person and have them involuntarily medicated because they violated a court order to take medication. So with all these remedies that you might imagine would come along with this court order taken off the table, it is a fair question to ask, what is the point? What are we seeking to accomplish? Is this more than a paper tiger? I would submit there are 2 points, 2 things we hope to accomplish, and I think the data I'm hoping to get to in my 8 remaining minutes will substantiate this. We are trying to impose what we call a black robe effect, not just on the person, but also on the treatment system. And this is rooted in the notion that judges, as authority figures in our society, naturally command respect and people's attention, right? It gets your attention to be told by a judge after you've gone through the ritual of a court hearing and a fair legal process, to be told this is something we need you to do, is just different in nature than being told by your doctor or your mom for the millionth time that you really need to be engaged in treatment. And I don't mean to suggest this works on everybody. There are people who will not be the slightest bit impressed by the edict of a judge. And AOT is not going to work in every case. But the idea is, for many people, for most of us, that is meaningful. And this black robe effect works on both sides. This is, at the end of the day, a mutual commitment. This is about the treatment team, the system, also understanding they've submitted a treatment plan to the court that they've averred will help this person get better. And the judge is going to also hold them to their end of the bargain as well, and let the person know that they have a right not only to, they have a right to expect good treatment in addition to their responsibilities to stay engaged with it. The second thing we're trying to accomplish here by putting this court order in place is to facilitate a rapid response to non-adherence if it were to occur. So the fact that we've made clear that there is no punishment associated with this court order should not be mistaken for a suggestion that nothing happens if you violate the order. There must be a process in place that's not about punishing the person, but rather is about trying to make sure that we are facilitating the help that they need. So typically under state AOT laws, when a person is disengaged from their treatment and their team has made good faith efforts to get them back involved and it's not working out, and there concern arises that this person may now need a modification of that order to an inpatient status, we can bring that person back in for a short-term hold to evaluate those needs. And that short-term hold may result in them going right back into the community because they're found not to meet inpatient standards. But ideally, we bring them back before the judge. We remind everyone that there are mutual obligations here. We remind the person that, you know, even though they can't be held in a hospital any longer today, we all know what happened the last 7 times the person was in this condition and disengaged from treatment. That's why they're under AOT in the first place. And so it's an opportunity to make an appeal to the person to please get back with the program. And the message that is sent by the program being proactive, by responding to the non-compliance, by bringing the person back in for an evaluation, is really all the teeth we need to make these programs meaningful and effective. I would like to make clear that this is a program not just for people who are presently refusing treatment. You don't need to reserve this involuntary order for people who come out of the hospital and say, yes, I'd like to be a part of a program like this, because there is a very familiar pattern with folks who do leave the hospital with the best of intentions to stay engaged with treatment, that they have trouble holding on to that intention. A couple of weeks down the road, they often start to tell themselves, I'm doing so great, maybe I don't need this after all. So we want to have that court order in place for everyone who meets these legal criteria, whether or not they are initially amenable to being part of this program or not. So we can do this through voluntary settlement agreements. We don't always have to have an adversarial hearing where the case has to be proven by clear and convincing evidence. If the person is admitting that they meet these criteria, we can have a stipulated court order. But in every case, we want to put a court order in place and have that person appear before the judge, because it is that interaction with the court that we believe is the secret sauce to the effectiveness of this program. Let me just jump to some of the data that speaks to the effectiveness of this program. We have studies in many states. Most of the data we have comes from my home state of New York, where this law was put into place in 1999. And there was, as in Maryland, some controversy swirling around it. And so the sunset was placed on the legislation with a requirement for independent evaluation to be done. And really, beyond those of us who were involved in creating this law's wildest expectations, this law was found to be effective in improving outcomes for people who are in this plight that I've described. Hospital admission likelihood cut in half, substantial reductions in the number of days people spend in the hospital, likelihood of arrest cut in half, meaningful reduction in the person's likelihood to commit violent acts when compared to a control group. Based on all this data, the law in New York has really become a fixture of the system there. I don't have a lot of time left, so I'm going to breeze through some of this other data. I would like to say that it was found that it's more than just the services that were identified as being important in New York. By a comparison they did with people who were under purely voluntary services in a very similar sort of program, but without the court order and involvement. Although those folks, by every measure, were found to have done better than they had done before, and that's absolutely an element of why this works, there were meaningful differences found between those voluntary participants and people under court order. Real ways in which the court order was found to add value that unfortunately I don't have time to get into, but could possibly in the Q&A. Respectful treatment was found to be the determining factor in terms of whether people felt stigmatized or coerced by being part of a program like this. There were people under AOT who had those negative feelings about the treatment system, but guess what? Lots of people not in AOT also had those feelings. And being in AOT was found not to be predictive of whether people felt stigmatized or coerced into public mental health treatment. It had everything to do with, surprise, surprise, how respectfully they felt they were treated by the folks they interacted with in that system. And there should be nothing about the practice of the AOT model that should ever interfere with treating folks with dignity and respect, incorporating a recovery model where we engage the person in the development of their treatment plan, etc. From a purely fiscal point of view, again, just an absolute no-brainer for any state to impose a program like this, because as demonstrated here, although there are areas in which spending did increase, if you look at these clusters of bars, you see that spending per patient actually did increase in certain measures because we were making sure people got better outpatient treatment than they did before, but absolutely dwarfed by the enormous savings that were represented by those second and third clusters. The cost of hospitalizing people by reducing their hospital days, we absolutely wiped away any costs associated with putting a program like this in place. This has become, because of this data and this information, an evidence-based practice that's been recognized nationally. It was mentioned that the sequential intercept model is coming to Maryland, which is very exciting to me because the Gain Center, PRA, has actually incorporated AOT into the sequential intercept model and intercept 0 and 5. Again, something we can discuss further in the Q&A. But I would like to speak just quickly in the minute I have left to how I see the OCC pilot program that was imposed in Maryland as being just fundamentally different from the kind of AOT program and law that I really believe Maryland needs. And I don't mean any disrespect to that program. I actually had an opportunity to visit it as a technical assistance provider working under contract with SAMHSA and the Gain Center. At the time, there was a SAMHSA grant in place. I observed the Baltimore project on that technical assistance team. And don't doubt that there were many people who were being helped by it. But I do have some real reservations as to whether it really meets the needs of the folks who we have described in this presentation I've given. There, from what I could tell, seemed to be a tremendous reliance on the voluntary option, so that people who met criteria were generally placed into the program without that court involvement. I think that was denying individuals the benefits of a court order, even for people who are willing to come into a program for reasons we've discussed. I think there is real good reason why you would want a court order in place for all those situations and have the oversight of the court. I also would submit that to the extent that the OCC program does have an involuntary component, from my observations, it was fairly illusory. There was no consequence attached to a person's non-adherence to being committed into this program. I did not see any way in which the treatment team was actually leveraging the court order in any way. It seemed more to me like just a box that had been checked rather than something that actually meaningfully affected the way folks were dealt with by the program. And I also would just add that, I think the criteria are kind of unfortunate as to what it takes to get somebody into the involuntary side of the OCC program. There is a requirement that the previous hospitalizations have been involuntary in nature for you to be placed under involuntary OCC. And I think the reality is that the distinction between previous hospitalizations being involuntary or voluntary tends to be fairly arbitrary. Many people who enter the system on an involuntary hold, who come into the hospital involuntarily because they're in crisis in the community, are persuaded to self-admit to the hospital. And so there is not a real meaningful difference between a past hospitalization that was voluntary or involuntary in the end. And so to limit the opportunity to be in this program under court order to folks whose previous hospitalizations were involuntary, to me, represents a tragic missed opportunity. So that is my basic presentation on AOT, and I look forward to answering your questions later, and thank you so much for giving me the time.
Thank you, Brian. I really appreciate your presentation. Are you willing to send that to us so that we can distribute it to members? Okay, that would be great. I think we're gonna just hold questions until we've heard from our second person on this panel, that we can ask questions of everybody at the same time. So I just want to check. Debbie Plotnick from Mental Health America.
Yes, I'm here.
Also, would you just like to say a few words?
Yeah, I'd like to share my screen if that's okay as well.
Yes. Is it saying that you can or can't?
Let me see. You cannot share your screen while the other participant is sharing. So I think Brian needs to stop sharing.
Okay, is it, let's see if I can figure out how to do that. I think probably the administrator can take that screen sharing power away from me. And that's probably how we're gonna have to do, because I don't know if I can figure it out.
Give me 1 second, I can go ahead and do that.
In the meantime, I'd like to say thank you to the committee, hello to the Lieutenant Governor, hello to Brian, and hello to my fellow advocates and parents who may be attending this hearing. Let me share my screen now. Okay. So my name is Debbie Plotnick, and I am Vice President for Federal and State Advocacy at Mental Health America. And I come from the affiliate field, and I have been in the affiliate field for many years, and I came to national about 8 years ago. And I have been having discussions such as the one we're having, in fact, many with Brian, for the past 15 years. However, let me tell you why I know what I know about. Let me see if I can get this to advance. There we go. So Mental Health America is the nation's oldest advocacy organization. It comes from always the voice of lived experience, people who have experience with mental health conditions and their perspectives. And you can see from our policy agenda from 1913, it's very much the same as the types of things we care about today, to keep people out of prisons and help them get health care, to screen children to see how they're doing, because mental health conditions begin in adolescence for the most part, to move dollars from custodial institutions such as large inpatient and jails to community-based programs, and to make mental health part of overall mental health. But I want to start with a personal story. I want to start with what gives me the legitimacy to be here with you today. That's a picture of me with my lovely daughter, Ashley. And Ashley, for quite a few years, has been saying to me, I should thank her for two things. And I do. One is my distinctive silver mane, and the other is the direction of my policy career. And here's why I know from whence I have come and why I know what I'm talking about when it comes to this issue. I know what families experience. I know how hard it is. I know what my family went through. This is a picture of Ashley in her early high school years, and you can see it's quite different from the smiling woman that you see today. At that point, she had 4 unrelenting years of being suicidal. of being impossible to deal with, of being just awful, revolving door of inpatient hospitalizations, partial programs, outpatients, and dozens of psych meds that sometimes she was willing to take, sometimes she wasn't, and other times she used in her suicide attempts. Why do I show you this picture of Ashley when she was young? Because where I lived at the time in Pennsylvania, age 14 was considered an adult. She had every right as everyone who was above age 18. How did I feel at that time? I'll tell you how I felt. I wanted to put a sack over her head and I wanted to put her in a closet and lock her up. I completely understand how parents feel and why sometimes they want court's help. Let me tell you what made a difference in getting Ashley help. It was getting it early. It was cobbling together a treatment plan. This was pre-parity. And I was able to do that not because I had necessarily more money, but I had more credit because insurance didn't cover things and our counties didn't cover things. But what Ashley taught me was by putting her at the center and what it is that she wanted and needed and asking her, that she became the quintessential example of getting well, of staying well, and of shared decision-making. I want to talk a little bit about my organization and what we've seen in the last few months since the beginning of the year and how that is relevant to today. So right now we've seen since the beginning that we started looking at states, and I will talk more about what we see of the state of mental health in America. Since we started looking 7 years ago, we've seen that more people have more worsening mental health than they had even when we began tracking this 7 years ago. And this is relevant, and I'll get to this in a moment. I want to talk about the increases that we've seen in suicidal ideation. So these are the things that have been happening now continually, and it begins when people are young. And we know that there are many things since the pandemic that are really adding to this. I want to move for 1 minute to talk about Mental Health America's screening program that we instituted a little over 6 years ago. And these are the screens that we have. But I want to tell you what's happened since COVID. Since COVID, since we began tracking from January to September, and we don't have October numbers, you can see that people have.
I don't know. Can you hear me?
Yes. Can you hear me?
Yes, we've had a request from the audience that could you actually put your presentation in presentation mode?
Oh, of course. I'm so sorry.
Yeah, people are having just a bit of trouble seeing.
I apologize. Let me see if I can make that happen.
And then, thank you so much. And then,
is it working?
If you can kind of fast forward to the point where we're talking about assisted outpatient treatment, that would be incredibly helpful.
I can't quite make it go into presentation mode. I apologize.
So it's the second button from the left is from current slide.
In the beginning. Let me see. Help
right
me
next
again,
to from beginning from current slide. It's second button on the left, Debbie. There you go.
Well, you're gonna have to exit out of this box first.
Okay.
And then go to from current slide.
There we are. Thank you for your technical help. Okay. Let me move through. The reason I'm showing the increase is so you can see how the needs have increased greatly. And I can just go through them very quickly. And loneliness and isolation are some of the biggest things. But the reason I mentioned the State of Mental Health America, we put out a report we have for 7 years. I want to talk about where Maryland is in the state of mental health in America. They have been for the last 6 years within the top 10. Overall, this year, Maryland ranks number 4. When it comes to adults getting services, Maryland is number 7. When it comes to youth and youth getting services, Maryland is number 4 again. So we're seeing that out of 51, Maryland has been doing a phenomenal job. So how does that compare to people who are not getting what they need? Well, I wanted to bring to your attention the kinds of things we think would serve Maryland very well. And it's number 1, treating health conditions like mental health conditions as health and not as legal and not as criminal. And therefore, more court orders are really not the way that Maryland needs to go. Maryland's doing a terrific job. Could they be doing better? Everybody can always do better. What I've shown you about our increase in people's screening, in the fact that we know we have young people showing more and more extreme anxiety, depression, and by the way, psychosis since the beginning of the pandemic. We know there are more people who need programs. So certainly Maryland needs to look at how they're spending their dollars for their existing programs, which are excellent, and continuing to be amongst the top ranked states, really, instead of more court orders. One of the things that I want to talk about with respect to AOT is coming from Brian's home state of New York. And New York has had Kendra's Law, but so far 4 states with 7 more lined up are looking to do what they refer to as the inset program, which has the criteria for people who meet AOT criteria. It's a model of integrated peer and professional services. And what we mean by peer are people with lived experience who are specially trained and certified to be able to connect with people. They're the people that have the instant rapport and therefore are very good at engagement with people. They're engaging them immediately. These are people who have frequent periods of that revolving door Brian referred to. And there are, with this program, peers that respond immediately. Families are involved in this program, and the people who have not been engaged are finding that when they have this kind of ongoing engagement activities with peers and the involvement of their families and their treatment team, they're coming off of their AOT orders in New York. And many people who meet the criteria are the people who are entering into the inset program. The inset staff has a coordinator, a team leader, recovery specialists who are peers, care coordinators, benefits, administrative assistant, and a nurse practitioner on call all the time. Why does this matter? Because we have to get people not just engaged, we have to ask them what they need. It's true what Brian says about many people not having insight, but what they have insight into is the fact that they do need something, whether or not it is to say they have a mental illness or not. They know that they need a place to live. They know that they need warm clothing. They know they need meaningful work. As they say, they like to see that they have friends, they have a place to live, they have meaningful engagement. And how does that work? Well, I could show you the same kinds of charts that Brian just showed you about saving those dollars, saving the counties. Now, this program in particular is the county program. I know that Maryland's programs are also county-based. It saves the county money, it saves the state money, it saves Medicaid dollars. Again, reduced inpatient days, jail costs, fewer police crisis calls, saving money, and court costs. Again, keeping participants housed, engaged, and reducing substance use. These are things that get people better and keep them better. Why is this important? It's important, again, because this is a health issue, and Maryland has been terrific at dealing with health issues. I want to say, if you would like to, and I will be happy to share these slides, on our Mental Health America website, we have COVID resources, the state of mental health in America. The brand new report just out today is there. The screening site is there. And from going to our main page, you can see the increases that we're seeing. So we know that more people have more intense needs. We know that many people have been around for a long time not having their needs met. Certainly, we need to engage them. And we believe that the way to do this is what Maryland has been doing. Terrific programs, terrific engagement. They can, if they're very interested in following some national models, do take a look at the New York program. And I'd be happy to answer any questions. And
Thank you so much.
my contact information.
Thank you very much. And if you'd be so kind as to send us your presentation, we'll send that out as well.
Indeed. And let me stop sharing my screen.
We do have several questions. I want to give deference to the Lieutenant Governor and my co-chair, Dr. Baniski. Would either one of you like to go first?
You can go to the co-chair. I'm listening primarily.
Okay, thank you.
So thank you both for your presentation. And my position right now is the Acting Director of Mental Health for the Department of Public Safety and Correctional Services. So I'm very interested in this because while I appreciate that Maryland is supposedly ranked by, doing fairly well, my prison system isn't showing that. With 25% of my population is, mentally ill and the revolving door. So I'm very interested in how this AOT could help those people, those patients who don't have family or are on probation or parole and last a month and come back. And I think that's where Maryland, could target a huge population of the mentally ill. Again, with 20,000 inmates and 25% of that, we're dealing with 5,200 people a month that are mentally ill and seriously mentally ill. So that is where I would hope that Maryland could go on this civil commitment part, so they could, bypass coming back and getting more connectedness. So Brian, I would like to hear if there's any other states that have that avenue from corrections.
Sure. Thank you so much for the question. The answer is yes. There's an enormous opportunity to make use of AOT with the population you're describing. I think it's important to draw the distinction between AOT and mental health court, which I think is another program that every community needs, right? A problem-solving court on the criminal side for people who have pending charges that are viable, but there's a realization that the person needs treatment much more than they need punishment, and an opportunity for them to get treatment in the community as a way of avoiding incarceration and hopefully have those charges dismissed. Where I think AOT comes into the picture and adds value to the opportunity to do mental health court is for the many folks who will not be eligible for mental health court participation because they are stuck in competency restoration limbo, right? And so their charges cannot go forward in such a way that they can be diverted into mental health court. There are many people who, although it's understood by all involved, they are going to get to the end of their attempted competency restoration period, and it's not going to happen. They're not going to get them restored in time, and so the charge is just going to get dismissed. If we could identify that likelihood up front such that we could dismiss the charge up front and move the person into civil commitment, inpatient if they need that for a while, but ultimately outpatient commitment, we can replace that wasted period of time where a person is stuck in a jail cell or a forensic hospital with an opportunity to get that person into treatment in the community, and I think take a lot of pressure off the criminal justice system that way. It also has enormous value as something that can be used for a discharge from a jail or prison, right? People who are receiving mental health services in jail and prison get that same kind of discharge planning that takes place when somebody leaves a hospital. And many will meet criteria for AOT. And so there is that opportunity through probation, through parole, and even when people have completely fulfilled their sentences to move them into AOT when they get back to the community.
I'd like to weigh in as well, if I may, please. Brian's right. There are too many people are in jail, and you're quite correct. And part of this goes to the fact that the systems are missing people and there isn't consistent treatment in the communities. There's too many places for people to fall down through the cracks. There's no question about that. But again, we're talking about health issues. And if we can deal with the health issues and we can engage people and keep them engaged, we do not need to keep them long-term, years under court orders. Do we sometimes, do folks need involuntary commitment? Of course they do. Have I signed hundreds of orders myself in my work in the field? Of course I have. But what we want to do is keep people from, as we say at Mental Health America, to before stage 4. Reaching them before, we want to talk about the intercept 0, keeping them out of the criminal justice system. And yes, too many of them are there. So we're talking about absolutely different kinds of things. And most states do have some kind of outpatient commitment. There's no question about it. They always have. And do we need that? Yes. But do we need the kind of criteria that AOT laws, and it's a very specific criteria. Do we need people under court orders for years? Probably not. Probably not most of them. But more importantly, we have far more people who are ending up in the criminal justice system who have not yet been adjudicated of a crime. And putting them under court order is keeping them involved in the criminal justice system, as opposed to keeping them solely in the healthcare system.
Thank you very much. Our next question comes from Kimber Watts, who is a subcommittee member. Are you on, Kimber?
I sure am. Thank you so much. First, Ms. Plotnick, let me just say thank you very much for your presentation. I sit on the Behavioral Health Advisory Committee in my capacity as someone as a family member with mental illness, and I can speak from personal experience that our journey was that it took about a year to get an evaluation, a year, which is a very long time in the life of a child. And even just to get therapy underway, which was a little bit better, there was a 3-month waiting period. We have good insurance. My children are well cared for. Their parents, me and my husband, are well educated and highly motivated. So what you speak to as to needing fewer court orders perhaps and more treatment options available in the community really resonates with me. I had some questions about Mr. Stetton's presentation, specifically when you were talking about Anosognosia, which I'm probably not saying. Yeah, that.
A while too.
in my capacity as assistant public defender, which I've been doing for 20 years, I've met many, many people who probably have that brain dysfunction, as you put it. And I guess my question is really whether a court order solves that problem. It's been my experience that for the most part, people do better with mental health treatment when they have some significant mental buy-in, when they are in agreement with the course of treatment. And as you said, when they feel like they're being respected. I just don't see how that seems inapposite to ordering them to do it. It doesn't seem that telling them they have to is going to really solve that problem to me. My other question was regarding the funding and funds saved. It looked like what you were saying was that New York had, for other reasons, perhaps increased its funding for community-based treatment. So one, if Maryland were going to implement this, wouldn't we first then need to also increase our funding for community-based treatment? And two, I guess, how did the study determine whether it was that additional resource of those community-based funds that caused the drop in expenses later rather than, AOT?
So let me start with the second one. What the study was looking at was the actual dollars spent on each per person who went through the AOT program. The actual dollars that were spent on them in the year before they went into AOT, the year after they initially were placed under a court order, and then in that third bar in each cluster, the year after that, by which time some people have graduated from the program, others have had their orders renewed and stayed in the program. So it's a simple finding that more dollars were spent on outpatient care for them to some extent, to an undeniable but fairly modest extent, right, on the average patient, but that a whole lot less was spent per patient on hospitalizing the person. In other words, these individuals were spending so much less time in the hospital that the spending on hospitalization, both New York State's own spending and the Medicaid reimbursed side of it, were significantly reduced. And so that's where the savings came from. As to whether those same savings could have been achieved through a purely voluntary program, I guess that's something reasonable people could disagree with, but there was another finding from the same data set, another part of the study, where they actually compared people under purely voluntary services to people who had a court order, and found again that while both groups did better than they had done before, there were some meaningful metrics by which people under AOT did even better, including, perhaps counterintuitively, higher engagement with their treatment, feeling more personally invested in what their treatment plan consisted of, which, we can speculate what that's about. My own theory is that it's about just the fact of having to go into court and verbalize it and talk about it led to a higher level of engagement. And I guess that kind of leads me to your second question about whether I think people who are not really understanding their need for treatment, lack insight, can benefit from being under a court order. I would certainly agree that it is optimal to do this without a court order. I think it's fair to think of a court order as a only when it has become apparent that a person doesn't do well under voluntary services because they have this habit of disengaging. And so the criteria should be about not just frequent hospitalizations, but linking that to disengagement from treatment. And then the question becomes, well, the voluntary services aren't working for this person. Can this court order add value? Can it make things go better? And, we don't really have to speculate about it because we have evidence, not just from New York, but from other states that suggests that it does work. And if that seems surprising, maybe it's because we're thinking of the court order so much as about being coercive and arm twisting and not looking at the reality of what AOT programs actually look like. These programs do embrace the recovery model. The judges are endeavoring to make this person understand that they are on their side, as is the treatment team, and reminding the person that it's a mutual commitment and the judge wants to hear about it if they aren't getting the services they've been promised. Judges are very focused on what each individual's life goals are, so that every time they bring them back for that hearing, that check-in, it's through the prism of what progress have we made since I last saw you towards helping your life goals. Again, really incorporating ideas from the recovery model. So, when you look at these programs in action, they are so much less about trying to pressure that person into doing what they don't want to do than in just creating an environment where the only thing that's kind of off the table is participation in treatment, and what the treatment looks like is something the person gets to say something about. And when they perceive that the judge is on their side, and at risk of sounding corny, when they come to feel the love of the treatment team and the court, their attitudes change. And I've seen it so many times, and the data speaks to it.
Brian's exactly right. Engagement really is the issue here. And many states do have AOT laws and they do not enforce them. And the orders are very, very rarely used. But it is about engagement. And one of the things that, as New York is also doing with their INSET program, is using peer engagement. This is the immediate engagement, the immediate set understanding. You don't have to wait for it to happen with a treatment team headed that is court ordered, or the judge getting in there and the people being okay with a judge. No, when you're working with peers, people immediately get it. And then the consistency of meeting their needs. They may not think they need treatment, but they know they need somewhere to live. They know they might need that cup of coffee and a cigarette as the first means of engagement. Am I in favor of giving people cigarettes? No, but if that's what it takes to engage them, and that's what they're telling me they need, that's the place. Do the systems need more money? Yes, they do. New York absolutely put a lot of money here, and that helps tremendously. Maryland has a huge commitment to funding their system and has had good results. I'm looking forward to Maryland having even better results. I know what a difference it makes when the money goes into the system, when the outreach happens, when the peers are used, and court orders become almost unnecessary. And even where, as I said, these laws exist, they hardly are used.
Thank you both very much. Our next question is from the Lieutenant Governor. And then we probably have time for one quick question before we move on to the pilot program presentation.
Okay, it's more, I guess, a comment. It sounds like a lot of times, I think both are correct. And I'm not an expert at all that. And I think there are places in between. I think there are a couple of things that to distinguish, and particularly going back to Ms. Boneski with regard to those who are coming out of the criminal justice system. they're further along in that intercept. And there's a difference between engagement of a youth, a young person who's having challenges, and the person that unfortunately they don't get treatment until they're in the criminal justice system. And so we need a mechanism, and it can be through the parole and probation process. It could be through early release. They're released into a program that, the AOT, or a program that will continue this outpatient treatment, and that there is some force behind it. Now, like you said, it's generally not looking at throwing them back in jail, but they're, understanding that this is a commitment that they have to meet versus giving them $50 a suit and letting them out on the street because they're just going to come back. So there's a distinction between that, like you said, the early intercept, when the person hasn't done anything to get them in contact with the criminal justice system, but the person who's in that 25% who are in our criminal justice system. And we're just talking about the prison system. We're not talking about the at the local level in the local jails. So that's a distinction that I think we should, keep in mind, that we need the ability to work with these individuals who are coming out of the criminal justice system, as well as to do that intercept, earlier in the process. And I point often to an article, and I would run over and grab it, that's right here from the Washington Post magazine about a year or 2 years ago, where the mother said that her son, who had schizophrenia, didn't get treatment until he's in Clifton T. Perkins, which is our mental health jail facility, basically. And so it's, what do you do when he comes out of that? And that's the challenge that I think is there.
Mr. Lieutenant Governor, you are absolutely correct. We ignore people, and we make them, when they need treatment and they need intensive treatment, meet the criteria for involuntary. We make them have to be danger to self or others. That has to stop. That's number one. We have to stop treating people through the criminal justice system. And the types of programs that I have talked about with the engagement, with the peers, in fact, their clientele are the types of people who have been through those revolving doors, who have been in and out of prison. And that's what engages them and keeps them going and keeps them from going back in. So we don't need that court order. We need those programs in place that follow the people in the community. In fact, I'm working with the Corrections Department in Colorado right now to train peer specialists inside the prison systems to help people who are in there, to get them ready to move out, and then to put them in these kinds of intensive peer engagement programs on the outside, again, without court orders.
I mean, you are the expert, but I will just say that New York has AOT.
Yes, they do.
They're using the engagement model, and we could use an AOT with the engagement model with our prison population. But also, just another distinction is between civil court orders and criminal justice. Just because you get a court order doesn't mean it's in the criminal justice system. Okay, it can be a civil matter. So I just, want the public to realize that we talk about the courts as if all they do is put people in jail. It is a means of handling disputes that come up. And in this case, it could be utilized for those who can't take care of themselves. And we can use the engagement model. I don't think it's an either or, but I'll leave it at that.
Yeah, I couldn't agree more, Lieutenant Governor. I think it's just a false choice that's sometimes presented between AOT and using strategies of engagement. When AOT is practiced best, it's based on strategies of engagement. The court order adds a tool that makes it a little bit possible to get a person's attention and to respond when things are not going as expected. But the way you work with people is still all about engagement.
Thank you both. I just wanted to reiterate that I hate to cut off a good conversation. We have a packed agenda. Brian and Debbie, if you're able to stay on and hear about our pilot program here in Baltimore, that would be great. And then we'll open it up again for 10 minutes of questions after that presentation. I also want to acknowledge that Richard Abbott, one of our committee members, has just joined, and also has Senator Augustine. So I'd like to welcome you both. And few questions, we'll put them first at the top of the list, after the next presentation. So with that, I would like to invite, Adrian Bridenstine to give us a brief summary of the Outpatient Civil Commitment Pilot Program in Baltimore. And then the OCC stakeholder panel will be invited to make a few remarks. I'd like to keep these as short as possible. So if you could just be as concise in your speaking as possible, that would be great. And we'll leave us a chance to ask a few questions at the end. Thank you so much. Over to you, Adrian.
Senator, and can you all see my screen? I just started sharing. Just want to make sure.
Yes,
we can.
Great, thank you. Thank you, Senator Hester, for having this be a topic of discussion at the community today. Thank you, Lieutenant Governor, for attending and being part of the conversation. I'm grateful for your attention to this issue because it's really important. As you've heard today, there's a lot of commonalities between what I've been hearing just from the first panel and from the discussion, and where there are some differences is just how we go about applying AOT or outpatient civil commitment. So I'm just going to be explaining the pilot that we currently have in the state of Maryland, the history behind it, where it came from in our philosophy. And I'm trying to move forward with my slides, but of course technology is not working. Are you guys seeing my slides?
yes.
The same slide?
No, the title slide.
Okay, I'm not sure what's going on. Sorry, Senator, I'm not sure what's going on, but I will just keep.
Now we see.
I'll start talking because I know you're on a timeline. So I'm just here to talk about the role of OCC, the philosophy and the history behind it in Maryland, and what we've been doing with the pilot program. Really quickly, I'm with Behavioral Health System Baltimore, and BHSB is a nonprofit that serves as the local behavioral health authority in Baltimore City. In that role, we have a function of managing the public funds and just overseeing the overall system of care. And part of our role in kind of oversight and system management has us well poised to play a role in implementing the Outpatient Civil Commitment pilot program here in Maryland. In a nutshell, as you know, OCC is in lieu of inpatient hospitalizations. We've heard a lot about what that is. Our outpatient civil commitment pilot partners that helped us to establish the pilot program in Maryland are many. I wish I could share my screen, but you could see them, but it's many of you who are actually attending the meeting today. We've got NAMI Maryland, Mental Health Association, Grace Medical, Office of Administrative Hearings, BHA, of course, On Our Own Maryland, the Maryland Hospital Association, Disability Rights Maryland. So I'm sure I've missed somebody, but I'm sorry I couldn't share my screen, but I wanted to acknowledge all of our partners. The quick history of the pilot program in Maryland is in 2016, we applied for a grant in partnership with the Behavioral Health Administration. BHSB applied for a grant through SAMHSA to establish the pilot program. We received that funding. As we were moving forward with implementing the program, we learned very quickly that we needed to have a pilot program. We needed to have something in statute to officially establish the pilot program in the state of Maryland. So in 2017, we passed HB 1383, which established the pilot program in Maryland. Move forward then with promulgating of regulations, of which we had 2 public comment periods. It's not uncommon to have 2 public comment periods, but because the OCC and AOT is such a controversial topic, as we're all learning, we did have 2 public comment periods on these regulations. And then our program officially started in the end of October in 2017. In 2018, we made the decision to return the funding back to SAMHSA. This paused the program for about 3 months. The pause of the program then led us to have to restart at the end of October in 2018 again. And so we kind of had a second shot at restarting this program. We've recognized throughout the process of having this pilot program that we wanted to make modifications along the way. So one of the modifications we wanted to make was to expand eligibility criteria. We did that through making revisions and again had to revise some of the statute. So in 2019, with the help of Senator Augustine and many others, we passed another bill which made revisions to the Outpatient Civil Commitment Pilot Program. And then finally, those revisions led to more regulatory changes. But one of the important regulatory changes is that expanded program eligibility to allow family members to request a referral to the outpatient civil commitment pilot program. Can you guys still not see my screen?
We can, you're just not in, now we can see it even in slide.
Now? Okay. Oh, good. I was playing around with it and got it fixed. Okay. So here, the overall goals of OCC are many of what you've heard today. We want to reduce inpatient hospitalizations, increase the connection to care, and just realize cost savings to the overall public behavioral health system, and ultimately improve the health outcomes for the people that we're here to serve. I will say from the very beginning, we have taken very seriously the impact of OCC on the lives of the people that the program is intended to serve. Like many of you have said today, we look at OCC as a last resort. It should be approached that is one of the tools within our toolbox, but it shouldn't be the primary approach, and should be used judiciously and applied in a manner that provides compassion and respect to the participants who are in the program. So with that approach in mind, that's how we initially approached it, and we've applied that approach in how we've made program modifications throughout the way. At a very high level, individuals, as you know, can participate in the program either involuntarily or voluntarily. The commitment period is 6 months. The program provides intensive peer support and overall connection to services. And then our role at BHSB is, again, to hold that system accountable to the person or the participants who are in the program. We have a dedicated position at OCC Monitor that oversees the individual's engagement in the services. It also manages the referrals into the program. As you know, the pilot program for now is just in Baltimore City. So I'll focus on kind of how we're different here in Maryland. We offer the involuntary and voluntary moment, but we use the peer support specialists as our primary method of intervention. Peer support specialists are the first people within the OCC program that our participants meet with. They're the first point of engagement outside of the hospital, obviously. But the other thing that's unique about our program is that individuals can have inconsistent or poor engagement, and they can still remain in that outpatient treatment setting. Our eligibility criteria is, it has changed since the program initially started. It has changed since you were involved with providing support, Brian. So for now, for involuntary, it's actually easier. There's voluntary and involuntary, and all it has, you see the eligibility criteria on the screen, but I want to point out for involuntary, you have to just have been retained anytime within the past 12 months, and does not have to be an involuntary retain or admission into a hospital. So the referral process is the inpatient facility makes a referral to BHSB. We look through it and make sure that meets that eligibility criteria. And then within 3 days, Grace Medical has their peer specialists, and they begin the treatment planning and engagement before the person is even discharged from the hospital. If there's an involuntary commitment, the hearing and settlement and all of that is scheduled with the Office of Administrative Hearings. That happens in the hospitals, and that's an important step for if it's involuntary. The role of our hospitals is to identify individuals, make that referral to us, and then they work with the peer specialist and the OCC program to work on that discharge planning together. I just want to point out, we don't look at outpatient civil commitment pilot program as the discharge plan. It's really meant to complement it and support the discharge planning that the hospital is already doing. Again, all of this is done in collaboration with the peer support specialists, again, which is our primary mode of intervention for our pilot program. The roles of the peer support, again, people with lived experience, but they know our system of care here in Maryland. Our peer support specialists do a variety of things. They schedule appointments, they do transportation, pick up medication for people, but they're that person that can be the motivator, but they can connect with the participants in the program in a very unique ways, a lot of the ways that you heard Debbie and Brian talk about earlier. What we have seen in our program is that the success is really with our peer specialists. Our participants find great value in their relationship with the peers. We have built into this pilot program an evaluation component, one that we partner with the Mental Health Association of Maryland, our CQT reports, which is where we've got some of these little success tidbits I have on the screen there. But we have had our participants with very complex medical issues come in as well, and the peer support specialists are able to help them with that in addition to their behavioral health conditions, and they've been able to stabilize. So just wanted to highlight that the success we have is very much in the stories, and wanted to share that with you today. And at this point, I think I will just turn it over to Dan, right, Senator?
Yeah, that would be that would be great. I just had one quick question. I mean, it seems like there are parts of this that seem very similar to AOT. So is this pilot in fact AOT, or is it not, or is there a gray area?
I think people use the terms interchangeably, but they are, they are different. It does have a lot of the same components. Where one of the things that ours is different is there aren't, as I noted earlier, trying to go back to the slide, is that people can still remain in the program if they're not adhering to their treatment. They would remain in that outpatient civil commitment pilot program, and in that setting. If people aren't adhering to their engagement or treatment, we look at that as that we need to do more, and there's more stepped up engagement. The other thing I think that is unique is the role of the local behavioral health authority in this project in really holding that system accountable. We have that dedicated staff person that closely, that's not the provider that's doing the direct service, that is tracking the person's engagement, the participants' engagement in the system of care, and ensuring that we are doing everything we can to make sure that the services and the wraparound supports are getting to that person. I think those are some of the components that makes Maryland's program unique, and what I would view as strengths in our program.
Excellent. Thank you so much for the presentation. And once again, if you're willing to send us the slides, that would be great.
Absolutely.
So, now we're going to turn it over to Dan Martin, who is one of several people who sit on the stakeholder panel for this pilot program. And Dan, we really appreciate you and the other stakeholders being here today. We are running kind of short, so if you can zoom through in like 5 minutes, that would be great. That will leave us 7 minutes for question and answers.
Yeah, well, thank you, Senator Hester. And again, thank you, Lieutenant Governor, Brian, Debbie, Adrian, everybody. I will zoom through this real quickly because, a lot of it has been talked about. I just wanted to share a few things. We talked about what's the difference between AOT and the Maryland OCC program, kind of highlight a few more differences and a few of the concerns that we have just with the more typical, I think, AOT model that haven't been discussed. Members of the OCC stakeholder group, several members of the OCC stakeholder group that were charged with implementing that pilot program sent a letter last week to the Behavioral Health Administration urging continued support for evolution of the Maryland OCC program and voicing opposition to a movement to a more preventative AOT program. And we ask about what's the difference between some of these programs, and as Adrian mentioned, a lot of the terms are used interchangeably. But there are fundamental differences, in the designs of these programs and the people that are subject to it, and the criteria and requirements of the particular laws. And so there are three real types of outpatient civil commitment across the country that have been established across the country. One is less restrictive alternative to inpatient admissions. And so this is where a court or administrative law judge orders adherence to a mental health treatment in the community in lieu of inpatient admission. So the individual has already met the involuntary inpatient admission criteria, but instead of going inpatient, they're given an opportunity to participate in outpatient treatment. So it's truly a less restrictive alternative. Another option is conditional release from an inpatient admission. So after a person has been involuntarily committed inpatient, they're granted their mandated treatment in the community as a condition for discharge. This is where the involuntary commitment under the Maryland OCC pilot falls, the involuntary component. And the third is really a preventive outpatient commitment, which is more the AOT model, which is where people that have not met an inpatient commitment criteria, but are believed to need treatment to prevent a likely hospitalization at some point in the future, are required to adhere to a treatment regimen in the community. And so, we hear a lot about there's 47 states with AOT statutes. Our research of the codes looks like a little different. There are OCC statutes in most states, but the way they're broken down across these three different kind of structures varies a lot. And you'll see that again, from our research, only a few states have that kind of more preventive AOT model, and even fewer actually make use of it. That's because, as we've discussed, AOT is costly and resources are limited. New York, as we've talked about, is really the only state with a comprehensive AOT program, and they pour hundreds of millions of dollars into voluntary services and enhanced services, and over $30 million annually for administrative costs. But there are serious concerns. I mean, that priority, despite this annual influx of spending, New York actually saw a reduction of voluntary service delivery in the first few years of implementation of its program. And this is due to the queue jumping phenomena, where priority is given to individuals that are court ordered for treatment at the neglect of those seeking treatment voluntarily. And I mean, this is really a concern for us. We talked about, this whole commission was created to really, increase access to mental health services. And we fight every year, for people that are looking to get services. They're actively seeking services voluntarily and can't get them. And now, we worry that, again, individuals on an AOT, a court order, will be kind of forced to the front of the line, neglecting those individuals that already can't access services that they need. And so another thing that I think is really, really important in this conversation is that there are disparities in how these programs are implemented. In New York, minority populations are at a much higher risk for being court ordered into treatment. This data is pulled directly from the Office of Mental Health in New York, the New York Office of Mental Health AOT website. And as you can see, Black and Hispanic individuals are much more likely to be ordered to court ordered into treatment. And so, real quickly, again, because I think this is super important, the evaluators in the program and the evaluation that Brian referenced back in 2009 find that there was no proof of intentional racial bias in the selection of individuals placed on AOT. But they did conclude that, and this is a quote, insofar as outpatient commitment statutes target a revolving door population that have involuntarily hospitalized patients who are concentrated in the public mental health system, it will inevitably select a greater portion of African Americans than their share of the general population, because that is the racial distribution of the target population for historical reasons. And again, it's that historical reasons thing that we're all talking about in this state and across the country, and the whole structural racism that leads to poor minority communities suffering more traumas, having less access to mental health services, having less quality services when they can access those services, ending up in crisis. And then now, for those societal failures, we're to believe that the solution is to court order individuals into treatment. And so, these concerns, again, I know we're short on time. There's concerns about the limitations of medications. I mean, which is, people in court order lose the right to make decisions about the psychiatric medications that they take, which is a real serious concern. We have really concerns about differences in opinion as to kind of the veracity of the, argument about anosognosia and whether, that's, whether it's an actual, legitimate medical thing. To be honest, it just calling it anosognosia and lack of insight anosognosia effectively discredits and dismisses an individual's legitimate concerns about for refusing psychiatric treatment in a single word. And so we have real concerns about that. And there, there's study after study after study that shows that it's not necessarily the most effective method, that AOT is not the most effective method, but there's also multiple studies that show that assertive community treatment, the type of engagement and outreach that we've been talking about, really does work. And this is the type of kind of outreach and engagement that the Maryland OCC program strives to deliver, whether the enrollee is participating voluntarily or involuntarily. And so, we on the OCC stakeholder program really believe in the program. We think it has merit, and we will continue.
Dan, you froze. I'm not sure if it's you or me.
We would urge a continued evolution. Am I still frozen? Am I still frozen?
You're unfrozen now.
Okay. Well, I'm done. I'm done now. So
Thank you so much for that, thoughtful response. So that was excellent presentation of the pilot. Does anybody have any specific questions about the pilot program? I'm just checking in the chat. Who is in the pink there? I'm sorry, I can't see your name.
Marilyn Martin. I'm just a mom.
Just a mom.
Just
What?
a mom.
Mom.
Not representing any organization. I just had a statement to read about my son.
Is
What
it a
do you
short
mean, just a
statement?
mom?
Well, I tried to get it down to 2 minutes, but it might be a tad more. Should I go?
If you can give us a shortened version, we would love to hear it.
Okay. I'm Marilyn Martin, the mom of an adult son who lives with schizophrenia. I have supported the establishment of assisted outpatient treatment, or AOT, in Maryland for over 10 years. However, in 2017, I testified that the OCC pilot program's criteria were too restrictive to benefit many of the people who need it. These criteria have not been changed for those who refuse voluntary treatment. My son had had at least 18 hospital admissions, yet never would have met the pilot's requirement of 2 involuntary commitments within a 12-month period for outpatient voluntary commitment. Like most patients, my son learned early on that agreeing to voluntary admission meant that he could then usually get out within 72 hours of signing a request to leave. When the nurse, for example, this was one time he could have used AOT. Usually if something changes, everything goes haywire. The nurse providing my son's monthly medication injection left his outpatient clinic, and my son refused the prescribed injection from the new nurse. This was when my son needed AOT. Instead, my son deteriorated so much that he assaulted my then 71-year-old husband, who ended up on the floor, bloodied from head wounds and traumatized. That was the first time he's ever been violent. My son now has a criminal conviction. Only after committing a crime could my son get court-ordered outpatient service. Now, even with a history of violence, he would not be eligible for the OCC pilot program, even if it were statewide. The Baltimore OCC pilot has provided no cost-benefit analysis that I've seen, or even important outcome data on hospitalizations or medication compliance. I would love to see this program continue, but totally redesigned according to the best practices as recommended by the American Psychiatric Association and the Treatment Advocacy Center. If a cost-benefit analysis of the revised program were done, including state and county expenses for police, incarceration, judicial system, and hospitals, I believe our state would recognize this as a win-win for all of us. That's it. Hope that was no more.
Thank you so much for sharing that personal story. It really puts a human face on the problem. It doesn't have an easy solution. Appreciate it. So I would just like, once again, we're at the top of the, well, not the top of the hour. We're at the time limit here at 4:30. I want to thank all 4 of our presenters for sharing with us their perspectives, both from the national level and the local level. I'd like to thank all 35 people who joined us for this hearing today. In terms of next steps, we'll be circulating the presentations and posting somewhere the recording of this video, so you can stay tuned for that. And several people asked me about written testimony, and I just want to remind you that you can send comments to, let's see, mbh.commission@maryland.gov. And so with that, thanks again, and to be continued. Everybody stay safe and have a good week.
Great to be with you.
Thank you.
Thank you, Senator. Good job.
Thank you so much.
Thanks, Senator.